Hello, welcome to Self-Evident Truth with the Grumpy Old Vet. That's me, episode 17. I know it's been a while since I've been on. There's a lot of things going on, a lot of things in the world going on. If you haven't figured it out by now, this is good versus evil. And don't lose heart. It looks like the evil's winning, but it's not. It rears its ugly head every now and then it goes away to return again. So the fight for good is never over. It's a continuous fight, and it's one that we all must take up. Speaking of good and evil, let's visit the Dewey, Cheatham, and Howe Roadshow. So three of our members, along with Christina Cramo, the chair of the Michigan Republican Party, were taken before Judge Olsaver. Again, remember, Judge Olsaver is a Whitmer-appointed judge. And the law firm that Brent Leiniger hired, who is Warner Necross and Judd, are the lobbying arm for the Chinese Communist Party for the Goshen battery plant in Michigan. So let's not forget that. And also, let's not forget that Brent Leiniger and Andrew Fink are very good friends. They drink quite often in the upstairs of a local establishment in conference, in private conference, quite often. And let's not forget that Andrew Fink received money from Warner Necross and Judd, the same people that are lobbying for the Communist Chinese Party in Michigan. He received money from them to run for none other than our state representative. So our three of our people, along with Christina Cramo, in the state executive committee, were sued for contempt because the judge said that we could not bill ourselves as the Hillsdale County Republican Executive Committee, nor could we call ourselves the Hillsdale County Republican Party, HCRP, and we were to cease and desist any of that. Now, if any of you remember my first motion, which was rendered moot by this moron, I argued three things. The first thing I argued was the political question doctrine. The second thing I argued was the unclean hands doctrine. And then the third thing that I argued was that they did not exhaust their administrative reliefs, which means they didn't have any standing until they had gone through all their administrative reliefs. And there was administrative relief that they could have sought with the Michigan Republican Party. They just didn't. And I don't know if that was out of ignorance or out of arrogance, but I would assume it was more out of arrogance than ignorance. So I believe it was October that there was a hearing in which our three people, along with Christina Cramo, because the state party still had David Mosby listed as the legitimate party chair in Hillsdale. And the reason why it was listed on MIGOP as that is because in February of 2023, when the judge said that he was not going to add the new 6 officers onto the restraining order, he said that it was best decided by that the people were best served by having MIGOP decide who the legitimate party is. And that was keeping with Michigan Compiled Law 169.211.6, in which it says that there can only be one legitimate, that there can only be one official county party, and that state central picks who that is. And so when it went to that convention, under the last act that Ron Weiser did, was to sign um, uh, the all of the documents that were passed at the February convention, in which where Christina was elected. Over 2,500 delegates had voted that we are the party and that Brent Leininger's not even a Republican anymore, and any of his followers are not Republicans. Because instead of following administrative uh, uh, fixes that were there that they didn't exhaust their administrative reliefs. They decided to go right to litigation. Now, a little funny thing, if you remember the Colorado Supreme Court saying that Trump wasn't going to be on the Colorado Supreme Court, um, I'm sorry, let me back up. Colorado Supreme Court said that Trump was not going to be on the Colorado primary ballot. That was dinner theater. Because in saying that, they said what they were going to do is stay their decision until they got a decision from the Supreme Court. The Supreme Court basically told the Colorado Supreme Court that political issues need to be determined by the electorate, not by the third branch of government. In essence, they said the political question doctrine, which is what every first year law student gets, is the political question doctrine. See, we the people are the ones that created the states, and the states are the ones that signed the Constitution that created three branches of government. So thereby the electorate is the great pool of authority, as Madison called it. And so it's the great pool of authority that should be deciding the political question, not the third branch of government, not Olsaver. So Olsaver said then that it was best decided by MIGOP. So MIGOP decided, it went before 2,500 delegates. 2,500 delegates voted that David Mosby was the legitimate party chair for Hillsdale County, and that Brent Leininger's group and those people that would go to litigation rather than work within the party weren't party members. They weren't Republicans. So when that came back, I guess that didn't set well with Olsaver because Olsaver didn't think that that's what the decision was going to be. So then he changed his mind and decided that he would name Brent Leininger chair of the Hillsdale County Republican Party. When he doesn't have the authority to do that, it's the electorate that does that. So now Christina Caramo, she can't do anything contrary to what 2,500 delegates have voted to happen, which was that we were the legitimate party, that David Mosby was the legitimate chair. So the name on the MIGOP website for Hillsdale was David Mosby. Well, Brent Leininger decided to sue her too, because he doesn't like anything that is America First. So he decided to sue her because David Mosby's name was still on the state website, even though the judge had ordered that we, us original six, couldn't bill ourselves out as the Hillsdale County Republican Party. Well, so Brent sued. He sued for contempt. And he decided to sue Christina Caramo too because she didn't take David Mosby's name off of the state website. I've never seen a bigger crybaby in my entire life, especially someone that claims to be a Gideon. Oh, Lord save that organization. So the judge then decided, Dan Hartman filed an appearance, and he argued the Heitmanis v. Austin case, which was settled in the Sixth Circuit Court, which is our circuit, our federal court, in which the Heitmanis case, which was just argued the other day in Kent County, is that a lower judge can't order something on an organization that is binding on the parent company of the organization. Such as in that Heitmanis case, they'd made a decision on the MIGOP, and the judge that made that decision thought that it should fall on the National Republican Party, the NRC, the National Republican Committee, um, his decision enjoined them. And when it went to Sixth Circuit Court, Sixth Circuit said, no, you can't make a lower court can't make a decision about a lower organization and have it be binding on the parent organization. That's basically what Heitmanis v. Austin said. And incidentally, in the Kent County case, that judge, who wasn't set in place by Governor Whitmer, argued the same thing. He brought up the political question doctrine. He said the court should not be deciding political issues. Now, their lawyer on the other side argued that it wasn't a political issue, it was actually fraud because someone was using the party name that didn't have authority to use the party name by who? State Central. So, how is it that one judge understands the political question doctrine, first year law study, but yet a Whitmer appointed judge doesn't have a clue? Oh, the three things that I argued in my Michigan Court Rule 2.116C10, which was rendered moot by the Communist Party lobbyists Dewey, Cheatham, and Howe, Warner, Necross, and Judd. I affectionately call them Dewey, Cheatham, and Howe because that's really who they are. So they their whole argument was that they didn't have enough time to answer my C10. Well, they never got me served in time, didn't give me 21 days to answer. I still answered, but the judge rendered it moot. The three things I argued was the political question doctrine and unclean hands. Now let's talk about the unclean hands doctrine. What had happened in April of 2022 is Marty Cash showed that she, along with others, were conspiring to make sure that the America First precinct delegate applications or affidavits of identity weren't going to be accepted, and they were going to try to fill those seats so that they could take control of the party. And in doing so, she violated Michigan Compiled Law 168.558 and 168.554, in which she accepted our affidavits. What's supposed to happen is once she approves that affidavit, the law says that she's supposed to send a copy of it immediately to the Secretary of State. Then we are supposed to be exposed to the public for the people that are going to be on the ballot. Well, she exposed us to the public, putting our name on a list and publishing it for 7 weeks, and then throwing our affidavits out at the last day so that we couldn't do anything, and then accepting 70 affidavits of the anti-Trump party in Hillsdale, the anti-Trump Republicans, Brent Leiniger and his whole ilk. That was a violation of the law. Now, here's the problem. They claim that we broke the law, but we were not elected officials. She's an elected official. For her to violate the law on us, to deprive our rights using her position of elected power, which is deprivation of rights under the color of law, it's a Title 18, 242, Section 1983 violation. That's not just a civil violation, that's a criminal count. That's a criminal offense. And all of the people that were in elected positions that conspired with her to do that committed a criminal offense. They also violated the bylaws on the 8/25 meeting of 2022 when they did not invite Jonathan Lindsay, and we have emails between Jonathan Lindsay and Brent Leiniger proving that he did not invite Jonathan Lindsay, that's a violation of the bylaws, to their meeting when they had their vote. So they broke the law and violated the bylaws, exactly what they were claiming we did. So that falls under the unclean hands doctrine. Now, any of your lawyers out there listening, correct me if I'm wrong on any of this. I'm more than happy to have you correct me if I'm wrong. The third thing I argued is they didn't have standing because there was administrative reliefs that they should have sought that they did not exhaust before taking it to law. Now, I get a lot of people going, well, I wish the two sides would just get along. Well, we would accept them, but they don't want to accept us. They just want us gone. That's why they didn't follow any of the administrative reliefs. They went right to litigation. And who did they get? A Chinese communist lobbying group to do it and put it before a Whitmer appointed judge. I don't know about you. I don't know about the people of Hillsdale, but that seems shady for people who are calling themselves Republicans. I just, I mean, I guess everybody has to make that decision at the ballot box, don't they? That's what it comes down to. Now, let's go back to this contempt. So the judge decided to find those three people on our party guilty of contempt, Christina Cramo and the Michigan Executive Board. And what his order was is he says the court assesses the following sanctions. This is the December 28, 2023 order from Judge Olsaver. Mr. Mosby is assessed a fine of $500 pursuant to MCL 600.1715. Mr. Smith is assessed a fine of $500 pursuant to MCL 600.1715. Mr. Gritzmaker is assessed a fine of $500 pursuant to MCL 600.17.15. Respondent Karamo is assessed a fine of $500 pursuant to Michigan Compiled Law 600.1715. Respondent Michigan Republican State Committee is assessed a fine of $500 pursuant to MCL 600.1715. 6 is the problem. Defendants Mosby, Smith, and Gritzmaker and respondents Karamo and Michigan Republican State Committee shall pay plaintiffs' attorney fees related to the investigation and prosecution of the contempt, the liability of defendants, and respondents for the payment of attorney fees shall be joint and several. Okay? Now, a lot of people in the state got really upset because they said, well, that could be $50,000. Some people said, well, it could be $75,000. I got news for you. It's way more than that. The paperwork itself measures 56.5 inches high. This is one of your county commissioners, the District 5 county commissioner that did this under the guise of being a Republican. Okay? So it got appealed. Well, here's what the appellate court had to say. The appellate court says the claim of appeal is denied for lack of jurisdiction because the order signed on December 28, 2023, which was an order of civil contempt that imposed fines and appellants and the other parties in the case is not a final order appealable by right as defined in, and they give the different Michigan court rules. And here's why. Additionally, while the December 28th, 2023 order stated that the appellants and the other parties shall pay, this is in quotation marks, shall pay attorney fees related to the investigation and prosecution of contempt, end quote, it did not determine the amount of attorney fees to be paid. Therefore, the order is not applicable by right as a post-judgment order awarding attorney fees. Quote, an order that merely grants the imposition of sanctions is not a final order if the amount of fees and costs remains to be determined, end quote. So basically what they were saying is Olsaver signed a big steaming pile of poo that a first-year law student would know wasn't a final order. You can't say, I want you to buy this car, and you say, well, how much? Well, I'm not going to tell you, but I'm going to order you to buy the car. Hello, it's common sense. If you're going to say they owe something, you need to put the thing there. So in a little bit of research, I find out that Jonathan Lauterbach from Dewey, Cheatham and Howe, Warner, Cross and Judd, was given a date by which they had to have the legal fees to the judge. They never turned them in. Now, why do you suppose that is? Why do you suppose that Dewey, Cheatham and Howe didn't give the cost of the lawsuit to the judge. Now, here's why. It's my assumption that it's one of two reasons. Number one, Brent Leiniger testified in court on the record, it's on the transcript, that a private donor, a single private donor, was paying the lawsuit, was paying Warner Cross and Judd. Here's the problem. If you all remember, in 2016, Dinesh D'Souza went to prison for 2 years, federal prison, because he had given more than $10,000 to his friend to run for Congress. See, it's against the law for a single person to give $10,000 or more than $10,000 in campaign contributions or in contributions to a Republican Party. Now, i.e., Brent Leiniger is claiming that the judge made him the chair of the Republican Party and he controls the Republican Party. That means that lawsuit, if he is the Republican Party, and by the way, he's not filed any paperwork with the state, and he wouldn't give up the name of the donor in court, that means that whoever paid that bill going to federal prison for 2 years, right? It seems right. If we don't have a two-tiered legal system, if we have the 14th Amendment, equal protection of the law, everybody's under the same law, then if Dinesh D'Souza went to prison for 2 years, that means that Brent's private donor could be going to prison for 2 years, federal prison. So that could be one reason why they didn't give a cost. Because the minute they give a cost, we're going to demand that we see receipts and payments and who paid to prove that is actually the cost of the legal fees. That could be problematic. That could be problematic for the people that decided that instead of operating through their administrative release through the party and the political question doctrine of letting the electorate decide, decided to take it to litigation and sue so that they can have power. They claim that they believe in the electorate, but it doesn't sound like it. I don't care what they say. I watch what they do, and what they do isn't what they say. So, possibility number two. This is just an assumption. Now you remember, Andrew Fink was a carpetbagger that moved to Hillsdale just to run for state rep. He took money from Warner Cross and Judd. His whole family is either judges or lawyers. They operate in that circle. Andrew also took money from Warner Cross and Judd to run for state rep. Warner Cross and Judd are the lobbying group for the Communist Chinese Party for the Goshen battery plant, that the people there don't want that battery plant there. Panetta, who's a Democrat, even said that if the Chinese come here in that battery plant, that they definitely will use that opportunity to do espionage in this country. That's coming from a Democrat. And yet, they're pushing to get it here. So, maybe the other reason why they couldn't give receipts for how much legal fees were owed is because maybe they were doing it as a favor for Andrew Fink to sue us for what favors he was giving them in the legislature. And he wants to run for Michigan Supreme Court? If that's the case, is that really somebody that we want as our representative, let alone somebody sitting on our Supreme Court? And also, if that's the case, then that's called in-kind donation. And if it's over $10,000, then Andrew Fink has committed a federal offense. So there could be a couple different reasons why Warner, Necross, and Judd, Dewey, Cheatham, and Howe didn't provide the judge with the legal fees. You decide. Maybe there's another scenario, maybe why they didn't do it. But why wouldn't they? Why didn't they? They were the ones that sought this lawsuit. They were the ones that pushed so hard. They're the ones that filed and sent out 56.5 inches of paperwork. Think about that. 56.5 inches of paperwork have been filed on us. You decide. Do you want America first? Or do you want these false Republicans that call themselves Republicans, that call themselves Christians, that won't take an olive branch, that don't want us to be around, that did nothing but sue when they had administrative reliefs to get it taken care of? They could have taken it to the electorate and didn't. And yet somebody the other day said, well, I wish you guys would just get along. I said, how do I get along with someone who's suing me? Am I supposed to lay down and just let them run me through with the sword? Is that what I'm supposed to do? Is that how you get along? That's not how I get along. I'll get along by coming to the table and talking. It's got to be a win-win for everybody. I'm not going to do this win-lose. Remember, we didn't sue them. Remember, they were elected officials that violated the law. They deprived us of our rights under color of law. That is a criminal offense. It's not just civil, it's a criminal offense. That's what happened first. That is the impetus to this entire situation. So, at the end of this video, I want you to watch a little thing we've got going on. We've got Chris Ann Hall and Richard Mack coming to the old Wilson Hall at 7 South Manning Street at 10 o'clock on Saturday, February 17th. And they will be there at 10 o'clock. Please come. Get there a little bit early. It'll probably be packed. And then at 3 p.m., they will be at the New Hope United Brethren Church at 5051 West Montgomery Road, right across Gilmore Road from the Camden Frontier School. If you're going to come early, because that's going to be packed. So I'll have a little advertisement at the end of here. So that's kind of what's going on. So you guys think about it, make the decision for yourself. Don't let somebody tell you what to think. Use your critical thinking mind and decide. There's nothing new under the sun, and usually it's the most plausible thing that happens that's true, not something miraculous. Right? In medicine, they always say if you hear hoofbeats, look for the horse, don't look for the zebra. So I'm just asking you, where's the horse? Decide for yourself. Now, with that, God bless Hillsdale, and may God bless America and save America. Thank you.
John Adams once said that our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. The founders brought forth upon this nation a nation of liberty. That idea of liberty was given to us in the Word of God. If we want to make America great again, it is up to God's people to restore the morality and religious ideals that our founders so eloquently wrote in the Declaration of Independence and the Constitution. Two documents that were divinely inspired. On Saturday, February 17th at 10 o'clock a.m. at the Sozo Church located at 7 South Manning Street in Hillsdale, Michigan, and then at 3 o'clock p.m. at the New Hope United Brethren Church located at 5051 West Montgomery Road in Camden, Michigan. Chris Ann Hall will be speaking on the Constitution, She is absolutely wonderful. Her ministry, along with her husband, J.C., is traveling the country teaching about the Constitution and why it is a religious and moral obligation of Christians to bring back our moral and religious founding principles. She is a law professional and an Army veteran. She really knows her stuff. A bonus will be that Sheriff Richard Mack will be joining her on stage. Richard won a Supreme Court lawsuit against the federal government that was the greatest 10th Amendment decision since the Bill of Rights was added to the Constitution. These great Americans do this for the generous donations of those that attend. Won't you please come and listen in fellowship as the good news of liberty is spread as it was intended by Romans chapter 13. Thank you. May God bless you, and may God bless America.
Speech created by AI with VoxMaker 2.5.3.